The U.S. Supreme Court is often tasked with clarifying what a law means for the nation's citizens. But when it comes to the Second Amendment, recent decisions from the High Court have created questions and piles of litigation about how the right to bear arms relates to bearing arms in public.
In 2008 and 2010, the Supreme Court issued landmark decisions that held that a law-abiding citizen has the right to possess a handgun in the home for self-defense.
Ben Van Houtin is the managing attorney of the Law Center to Prevent Gun Violence, headquartered in San Francisco. He's one of the country's experts on the various interpretations of concealed carry.
As a result of those decisions, there are plaintiffs challenging a wide variety of laws across the country.
We're glad the Supreme Court acknowledged it was an individual right. What it has done is invite us to litigate for the next 50 years over every gun restriction on the books in the United States.
Michael Hammond is legislative counsel for Gun Owners of America, an organization that brings litigation challenging concealed carry restrictions. But despite a number of lawsuits, the courts have not been friendly to the cause of the gun lobbies. Here are the rulings that have jammed the plans of gun rights advocates. The Fourth and Second Circuit Courts ruled that governmental bodies that establish requirements for receiving a concealed carry permit are not violating the Second Amendment. And the Tenth Circuit decided that the Second Amendment conveys no right at all to carry a concealed and loaded firearm in public. The Seventh Circuit, however, ruled that a state cannot completely prohibit the concealed carry of firearms. Despite these seemingly disparate rulings, activists on both sides don't expect this issue to be solved in the nation's highest court.
Well, I think that there will continue to be Second Amendment challenges to a wide variety of laws. And what we've seen from the trends, it's that courts are hesitant to rethink the judgments of legislatures in this area. You know, in some of the recent concealed carry decisions, the courts have talked about, well, this is an area best served by the legislatures. And I think when it comes to gun laws, that's going to continue to be where those issues are discussed.
I think that's what we have to rely on. Increasingly, I think the process of the federal courts is becoming a politicized one, and I think it's foolish to just allow them to pass bad laws in the thinking that the courts will bail us out.
The final decision on this matter may come not from the judicial system, but from the halls of Congress. At the U.S. Supreme Court, this is Greg Presto for the Lawyers.com channel.